Good evening and welcome to the second webinar in our latest family law series. I'm Alison Pryor and I'm here with Mark Chaloner this evening, and we're going to talk about to fact find or not to fact find. There'll be a chance to ask questions at the end. Please, could you put your questions into the Q&A box? If we do run out of time to answer them, then we'll follow up later on via email. If you're watching this recording later on, then please email any questions to events@42br.com. An email with this recording and slides and a feedback form will be sent out over the next few days, and the recording will also be made available on our website and our YouTube channel.
Thank you. So in which case we will start. Broadly speaking, the way we're going to do this is I'm going to discuss the private law aspects of fact finding or not, and Alison's going to discuss the public law aspects of to fact find or not, and then we'll pull it together at the end. And so on that basis, starting with private law, obviously in my mind, starting point is, in modern times, re-HN, which was of crucial importance in this field. And re-HN, of course, introduced, highlighted, first of all, PD12J, the practice direction with which I'm sure you're all more than familiar, setting out how the courts should deal with allegations of domestic abuse, highlighting the serious nature of those allegations. And re-HN confirmed that for the court's perspective, PD12J is fit for purpose, and it is expected to be followed by the courts. And to be frank, almost all of the cases thereafter have looked at whether PD12J is truly being complied with in practice. But PD12J itself remains the starting point and end point, really, in private law, certainly, of considerations of fact finds, and particularly how domestic abuse is to be dealt with. So in re-HN, while we're dealing with it, of course, that was the case that established once and for all the primacy of coercive and controlling behaviour as a concept that will need to be looked at within private law proceedings, whether it's present and if so, the impact of it. It also looked very firmly at the need and scope of any fact-finding hearing. And what the court said in that regard in re-HN was that actually, because coercive and controlling behaviour is a wide concept, the old principle whereby perhaps you might have had a Scott schedule with 1 or 2 allegations or 5 allegations, the concept of picking your best was not going to be suitable any longer, because actually it maybe you have to get a picture of the whole nature of the relationship before, in fact, it was possible to determine whether there was coercive and controlling behaviour. And so there is likely to be a wide scope to fact-finding hearings on re-HN's basis. And it also highlighted, as I say, the primacy of domestic abuse and therefore the need for fact finds. But I will come back to that. That's how I read re-HN, but as I will return to in due course, it may be that I misread that at the time. So re-HN also dealt with Scott schedules and talked about whether they were helpful or not. And as I've indicated, fundamentally, the view was that they're not necessarily helpful when looking at coercive controlling behaviour, because you have to take into account the full width of behaviours. And also, it was very clear, one of the cases that made very clear that criminal concepts do not apply to family law. Family law is not trying to find out whether a defined crime has occurred. Rather, in family law, what we seek to do is establish, in fact, what happened, how it could be described, describing it, and the impact of it is a different process to the criminal courts. Re-HN, as I say, fundamentally to me can be summed up by paragraph 37, and it looks at PD12J. In terms of whether to hold a fact find or not, the court was very clear at paragraph 37. First stage, consider the nature of the allegations and the extent to which it is likely to be relevant in deciding whether to make a child arrangements order, and if so, in what terms. And then in deciding whether to have a fact finding hearing, the court should have in mind its purpose, which is in broad terms to provide a basis of assessment of risk. So that is why we hold fact finds according to re-HN, and therefore that is what we need to consider in deciding whether to fact find or not, and therefore the impact of the alleged abuse on the child or children. ReHN went on to say careful consideration must be given to PD12J paragraph 17, whether it's necessary to have a finding of fact hearing, including whether there's other evidence which provides a sufficient factual basis to proceed, and importantly, the relevance to the issue before the court if the allegations are proved. So again, it's all about relevance, necessity and relevance. At that stage as well, paragraph 17, which is another topic we'll return to, the court has to consider whether a separate fact-finding hearing is necessary and proportionate. A vexed issue, and in my view it remains a vexed issue, is whether you have a separate fact-find before a final hearing, a final welfare hearing, or whether the two can be rolled up together. And in ReHN, it was right. The President's guidance set out in the road ahead was dealt with, and it talks about the overriding objective. So there was an eye in ReHN, and one should have had an eye when reading ReHN to the need for proportionality, in essence, in dealing with fact finds or not. ReHN was followed by multiple cases. The first I want to refer to is the decision of Mr. Justice Hayden in F and M. And again, really, this was a case about domestic abuse and coercive and control, and establishing the primacy of coercive and controlling behaviour in looking at domestic abuse. And Mr. Justice Hayden was very clear. Understanding and evaluating coercive and controlling behaviour requires isolating what may sometimes seem to be relatively innocuous incidents and locating them in a context which illuminates their greater significance. Now, the importance of that in deciding whether to have a fact find or not is it makes quite clear you have to have, in effect, a wide canvas in looking at coercive and controlling behaviour. Moving on, the next case I want to refer to is ReBB, and that again dealt with how fact finds should be approached in light of ReHN. This entered first of all into the debate really around, having said Scott schedules may not be suitable, what do you do? Because you do still need to deal with allegations. And so in ReBB, the suggestions put forward that evidence might be put forward in so-called clusters, so grouped issues, as it were. ReBB did highlight that the need was to focus on the issues necessary to determine or dispose of the case. So again, there is this relevance issue that's being highlighted by the court. And following on from that, rigorous testing at case management stage, what real value is likely to be brought to the inquiry by the evidence of third parties. Again, looking at necessity, you'll have to consider the necessity of whether a fact find's held at all. But if you're going to hold a fact find, you need also to consider what evidence do I really need to determine it? Because certainly in private law, and I'd suggest in public law as well, the danger is there are always witnesses that could be called, but it's whether they will actually assist the court or not. ReBB did also highlight judicial continuity, or the need for it. However, we then come to K and K, and K is in effect now, I would submit, the lead case in relation to fact find or not in private law. It highlighted, first of all, the use of MIAMS and non-court dispute resolution, as we now call it, although that's not actually a phrase that's used in K&K, and the need to consider that at an early stage. It made very clear the first hearing dispute resolution appointment for HUDRA, and I know other people say that in other ways, is to be used effectively, and reasons need to be given for deciding whether a fact find is needed or not. And time should be given. I'm bound to say this is difficult to see in practice in a busy list, but time is to be given where necessary for the parties to identify the factual findings that they seek to contend should be decided by the court. And again, it highlighted fact finding is likely to be relevant to what the court is being asked to decide in relation to children's welfare. The basic point is if it's not relevant to the children's welfare, you shouldn't be asked to decide it. The court shouldn't be dealing with it. It's all about the children's welfare. And K&K set out very clearly that the judge ought to have considered all the allegations in the context of the contention that most fundamentally affected the question of future contact. So in that case, whether the father was demonstrating coercive and controlling behaviour affecting the children's welfare. So you have to look at it all on the context of the fundamental questions. However, K&K continued on and suggested or dealt with, if you like, how ReHN should be read in terms of the way in which the decision to direct a fact find should be considered. First of all, in K&K, the court was critical that actually there had been a premature decision, so a decision too early as to whether a fact find was needed or not. In that case, a fact find was ordered even though when it was set down, the mother hadn't identified the allegations she wished to pursue and all the relevant disclosure hadn't taken place. The court was very clear that wasn't appropriate. You can't say in truth whether you need a fact find until you have all the relevant information on the table to consider. And it set out very clearly the main things the court should consider when deciding whether to order a fact find are, first of all, the nature of the allegations and the extent to which those allegations are likely to be relevant to the making of a child arrangements order. So again, that is almost word for word taken from REHN. That the purpose of the fact find is to allow assessment of the risk to the child and the impact of any abuse on the child. So again, it's all about the child and the impact. And then finally, whether fact finding is necessary or whether other evidence suffices, and whether fact finding is proportionate. What's interesting in K&K is the Court of Appeal refers to REHN and indicates it may inadvertently have been misunderstood in the sense that it appeared to the Court of Appeal in K&K that practitioners had perhaps taken REHN as an invitation for more fact-finding exercises, whereas actually in K&K they arguably tried to pull it back and said, no, it's all about necessity, it's all about relevance. And actually REHN is not necessarily saying there should be an increase in fact finds. They were very clear what is required in a private law fact find is to consider an overarching issue of coercive or controlling behaviour where to do so, and they don't say it, but only where to do so, is necessary for the determination of a dispute relating to child's welfare. It's not a requirement for the court to determine every single subsidiary factual allegation that may be raised. The court only decides individual factual allegations where it's strictly necessary to do so, in addition to determining the wider issue of coercive or controlling behaviour when that itself is necessary. The court couldn't have been more clear. It is not holding a roving brief to examine all the matters the parties want. It will look at what is relevant to the children's welfare, what is relevant to deciding the outcome for the child. But it may well mean it will say to parties, however, we are not going to explore issue X or issue Y because it doesn't go to that purpose. That then brings on to more recent cases. And I'm very clear, as I say, that K&K is in essence the lead case still. And more recent cases fall into two camps, unsurprisingly. There are the camps where, in fact, it was found appropriate to hold a fact find, and there are the camps where it was found, in fact, a fact find wasn't required after all. So the first recent case I draw to attention is Ms. X and Mr. Y, a decision of Mrs. Justice Leven. And in that case, Ms. Justice Leven was faced with a situation whereby there had been delays within a case. And in fact, at one stage, counsel for one of the parties was arguing for a listing for 8 days. But in that case, there had been convictions for coercive control. And Ms. Justice Leven was very clear that in those circumstances, there could be no justification for a fact find. In fact, the matter was dealt with at a one-day final hearing. And there are some very useful comments in there that where there are convictions for coercive control, it is not clear why a fact find is going to be required. It's not saying it's impossible, but it is unlikely to be required because the conviction in itself has already dealt with fundamentally the factual basis. And so, as I say, Ms. X and Mr. Y, where there are convictions, a fact find unlikely to be required. TRC and NS is another interesting recent case, again, of Mrs. Justice Leven. And in that case, magistrates decided not to hold a fact-finding hearing, despite the fact that, in fact, there'd been a previous prior decision that there should be a fact-finding hearing. The reason that they determined it wasn't necessary to hold a fact-finding hearing was that, in fact, since the initial decision had been taken, further matters had come to light. In particular, there had been transcripts provided of the parties and their interactions, and some limited admissions, but some admissions. And on that basis, the magistrates decided that, in fact, it wasn't necessary to hold the fact find that had been listed. That was appealed, and Mrs. Justice Leven was invited to find that the findings of the magistrates were unsafe because they had refused to hold a fact find. The first point made by Mrs. Justice Leven is that there's not a formal process to follow in terms of deciding whether a fact find is to be held or not. Rather, one's expected to go through the factors to show that they've been considered by way of a court, but there's not a specific procedure. And it is quite clear from Mrs. Justice Leven's comments that not all matters require fact finds. And in that case, she upheld the decision of the magistrates that actually a fact find wasn't required in that case. The admissions were sufficient. And if one looked at the issues in the case, which actually were the amount of overnight contact, but not the concept of overnight contact, it wasn't going to be relevant, in fact, to determine the allegations to make the final determination. What is interesting is Mrs. Justice Leven also, within the case at paragraph 45, noted that in her view, fact finds will often be neither necessary, a separate fact find, will often be neither necessary nor indeed helpful in a private law dispute such as this. So Mrs. Justice Leven is setting out very clearly a view that actually it may be appropriate to have a rolled up final hearing, as I would call it, rather than a separate prior fact find before a welfare decision being made. We then come on to A and K, and in that case, on day one of a 3-day hearing, the trial judge had decided not to hold a fact find on the basis that, in fact, it was not clear to the judge that it was necessary for the welfare decisions. It went on appeal to Mr. Justice Cobb, and he upheld the first instance decision that a fact find was not necessary. Again, if you wish, this was a late decision, day one of a 3-day fact find, that actually the fact find was not necessary. In fairness to the trial judge, it was the first time that trial judge had seen the case, and the trial judge had emailed the parties a few days prior to indicate that they weren't clear necessarily what the issues were that required determination. And it's an interesting case to read because it sets out very clearly, if you wish, how a judge can, and indeed in that case well justified, not holding a fact finding. Against that, we have a series of cases where, in fact, or 2 cases, I should say, where in fact fact find was held not to be proportionate. So the first case is Re O. And in Rio, the position was that, in fact, what happened was that a decision was taken not to hold a fact find, and that was appealed to Ms. Justice Henke. And the decision was taken that, in fact, the judge hadn't given proper consideration of a fact find. In fact, in that case, the parties hadn't been asking for a fact-finding hearing, but it was held that afterwards issues had been raised, and had the judge been thinking more clearly about matters and had they been brought to the judge's attention more clearly, it was a case where domestic abuse was going to be relevant, and there was a duty upon the court to consider whether a fact-finding hearing is required or not. And they held that the recorder in that case should have considered the need for a fact find. And that was in spite of the fact that actually there had been a prior determination by magistrates that a fact find was not required. And there had even been prior non-molestation order proceedings which had been compromised in essence with no findings. But as I say, Mrs. Justice Henke was very clear that actually that recorder should have looked at the issues on in the case and decided the fact find was going to be relevant, was going to be required. And so on that basis, the matter was remitted and a fact find was held to be required. Then we have finally, in relation to the private law world, a recent case from March of this year, MZA and FHB. And there, Her Honour Judge Vincent, sitting on appeal, was considering a decision not to hold a fact find, and was very clear that if you're going to be dealing with whether to hold a fact find or not, it is imperative that you consider in private law context PD 12J, particularly paragraphs 35 to 37, consider what the impact of findings might be in effect a counterfactual way, and it also whether it's procedurally fair in how the question of whether a fact find is required is raised. And so again, it's an interesting case going against the need for a fact find. So in private law at the moment, in short, we're in a position whereby K&K is the lead case, necessity and relevance are stressed, and as I've indicated in the last two slides, there are cases going both ways as to the necessity not to hold a fact find and necessity to hold a fact find. I'll now hand over to Alison to deal with some public law cases on fact find or not.
Thank you. I'm going to start with the relaunch of the PLO.
Oh,
find my.
I apologise. I realise that apologies. I've realised I've skipped some slides. So do you mind if I just go back?
That's
and
fine.
I apologise. So what I should say is, having dealt with the cases, what in fact should be looked at as well in recent times is the Cafcass domestic abuse protocol. And forgive me, I'm just slightly concerned that the slides aren't moving on my screen. So I hope they're moving for you all at home. You may have heard about the Cafcass domestic abuse protocol that came out within the last month. And that protocol has yet to be looked at in any meaningful sense by the courts. However, it is my view that may well change, in fact, the way in which the protocol, the way in which fact finds are considered by the courts. The Cafcass domestic abuse protocol sets out a number of starting points. And they are starting points for Cafcass officers in considering whether fact finds are required or not and how domestic abuse is to be dealt with. The starting points, however, are going to be relevant. I'm not going to go through all the slides. I've set out 7. I've highlighted key points in relation to the Cafcass domestic abuse protocol, so you can look through them in your own time. And as I think has already been said in the chat, in fact, the slides will be emailed out in due course. But the important point is that what Cafcass have done is highlight that, for example, in cases where there is a allegation of sexual abuse or sexual matters, and that would include logically rape against a parent by the other parent, then actually the starting point will be that there will not be contact, and the starting point will be that contact would have to be justified in order to for the Cafcass officer to recommend it. The position is that arguably was the case in under PD 12J, because obviously the court would have to justify why it's making orders when allegations are outstanding. However, it cements it in a way that perhaps we hadn't seen. And likewise, in relation to domestic abuse, although there's not the same level of starting point, the position is that domestic abuse protocol is quite clear that there's going to be a high level of justification needed for Cafcass when allegations are outstanding in relation to whether or not they should in fact be putting forward a fact find. Now, at the moment, we don't know how the domestic abuse protocol is going to pan out. We're going to have to see whether in fact, in truth, that amends or not the approach of the courts. As I say, it's a Cafcass document, which will inform Cafcass recommendations. It doesn't change the law in and of itself, but it may affect the way in which Cafcass officers are making recommendations. And we'll have to see about that. And I apologise to Alison, who will now go on to public law.
So I'm going to start with the relaunch of the PLO, which I'm sure all of us are very familiar with. This was done on the 16th of January of last year. And the aim was to reset the family justice system so that, and I quote, it reconnects with the strictures of the PLO and once again aims to meet the statutory requirement of completing each public law case within 26 weeks. The stated aims are to have no more than 2 or 3 hearings per care proceedings. And as I've just said, to conclude proceedings where it can be done justly within 26 weeks. And there were reminders of the issues that the court should consider or is only required to consider at the ROH and final hearing. And the court's not required to consider any aspect of the care plan other than the permanence provisions. So where does this leave fact-finding hearings in light of that?
Sorry, I'm just going to intervene. So I don't think the slides are moving on for those of you online. So I'm not sure. Apologies. So I'm not sure the slides are working for us tonight.
Well,
I'm sorry about that.
That's it.
There you go.
You.
I think you're on the next one.
That one, yeah.
Yes.
Thank you. So Mr Justice Kean said this about the place of fact-finding hearings in light of the PLO relaunch. Split hearings, including fact-finding hearings, cause unacceptable delay and should be reserved for truly single-issue cases or where welfare planning cannot be concluded without a determination of the core disputed facts. So we're going to look at now how courts are approaching the decision of whether to list fact-finding hearings in response to that. And I'm going to start with the case of a local authority and X and Y need for a fact-finding hearing, which is a 2024 case, a 2023 case, I apologise, of Mr Justice MacDonald. These proceedings were concerned an 11-year-old. Zed had two older sisters, one of whom was M, who was intervened in the care proceedings. M had had two children. The first one had died some years previously, and the second child, C, died in 2022 when they were just 6 months old. The issues in the case for Zed were neglect, essentially, and a psychological assessment had concluded that he had had a number of multiple adverse childhood experiences and he needed therapy within a secure placement. He was currently well settled in a placement, but his parents, who had, it said, long-standing issues, sought his return to their care. Although the cause of the death of M's first child hadn't been ascertainable, the police then opened an investigation into that following C's death, and the mother and M were subsequently arrested on suspicion of murder of C and cruelty and neglect in respect of both C and Z. C and the older child. The post-mortem report on C remained outstanding. What the court had to determine was whether it was necessary to hold a fact-finding hearing into the cause of C's death in order to determine the proceedings in respect of Z. The local authority, the father and M all invited the court to adjourn the determination of that question until the post-mortem report had been received. The mother, on the other hand, invited the court to determine the issue now, and the guardian's position was that the court should determine that it was not necessary to hold a fact-finding hearing into C's death. The court refused to adjourn the hearing and decided that a fact-finding hearing on the cause of C's death was not necessary for the ultimate welfare decision in respect of Z. And it said the following: whilst it was a matter for the local authority to determine whether to bring proceedings under Part 4 of the Children Act, once those proceedings are before the court, it's for the court to decide which issues require determination. The court has broad powers of case management pursuant to the family procedure rules, and it went on to list some of those: the power to direct a separate hearing of any issue, to exclude an issue from consideration, and to take any other step or make any other order for the purpose of managing the case and furthering the overriding objective. It went on: pursuant to Section 32(5) of the Children Act, the court can only extend the 26-week time limit if doing so is necessary to resolve the proceedings justly. And in this regard, only fair process or the child's welfare will suffice. And in that context, the court said that the law governing the case management question of whether or not to conduct a particular fact-finding exercise is in fact well settled, and the question falls to be resolved by reference to the factors identified in what's known as the Oxfordshire case, considered and expanded on in Re HDH. Those are two earlier cases, very familiar, I'm sure, to you all. We're just going to have a look at those now. So it's really a question of back to basics. The Oxfordshire case was a 2005 decision in which Mr Justin McFarlane set out the factors that are most relevant in deciding whether to order a fact-finding hearing. And those are the interests of the child, relevant but not paramount, the time that the investigation will take, the likely cost to public funds, the evidential result, the necessity or otherwise of the investigation, the relevance of the potential results, the future care plans for the child, the impact that the fact-finding process would have on the other parties, the prospects of a fair trial on the issue, and the justice of the case. In Re HDH, a 2021 case, the Court of Appeal considered two cases in which case management decisions have been made not to investigate and make findings about serious allegations. In a moment, we'll look at what was said in that case about the application of some of the Oxfordshire factors, but it was also said that the fundamental principles didn't change in response to workload, and the proper approach had never been to leave no stone unturned in these cases. And what was described as a desired shift in professional practice could be achieved by paying fresh attention to the fundamental principles of good case management. So as to the Oxfordshire case, paragraph 21 of the judgment in re-HDH, the court noted that many of the factors in the Oxfordshire case overlap with each other, and the weight to be given to each of them will vary from case to case. That being said, the necessity or otherwise of the investigation is always going to be a key issue, especially in the current circumstances where resources are so tight. Every fact-finding hearing has to produce something of importance for the welfare decision, but the court said the shorthand of necessity doesn't translate into an obligation to conclude every case as quickly as possible, regardless of other factors, and that's said clearly not the intention of the administrative guidance. Also, there'll be cases in which the welfare outcome for the child isn't confined to the resulting order. Not infrequently, a finding in relation to one child will have implications for the welfare of others, and sometimes findings that cross the threshold at a minimal level will not reflect the reality. And the court said that the broad obligation of the court is to deal with the case justly, having regard to the welfare issues involved. And they reminded us of paragraph 21 of the Oxfordshire case, where the question was being whether on the individual facts of each case it's right and necessary to conduct a fact-finding exercise. They went on to say that the factors identified in the Oxfordshire case should be approached flexibly in light of the overriding objective in order to do justice efficiently in the individual case. And they went through each of the factors and gave a little bit of further guidance. So, for example, when considering the welfare of the child, the significance of the individual child of knowing the truth can be considered, but so can the effect on the child's welfare of an allegation being investigated or not. The likely cost of public funds can extend to the expenditure of court resources and their diversion from other cases, and the time the investigation will take allows the court to take account of the nature of the evidence. With the evidential result, that could relate not only to the case before the court, but also to other existing or likely future cases in which a finding one way or the other is likely to be of importance. They looked at the fact that the impact of any fact-finding process on the other parties can also take account of the costs for the local authority, interestingly, even if it's the party seeking the investigation, in terms of the resources and professional time that might then not be devoted to other children. And then finally, the justice of the case gives the court the opportunity to stand back and ensure that all matters relevant to the overriding objective have been taken into account. And one such matter, for example, is whether the contested allegation might be investigated in criminal proceedings, and others the extent of any gulf between the factual basis for the court's decision, with or without a fact-finding hearing. And the level of seriousness of the disputed allegation might also inform the assessment. What the court has to ask itself is whether its process will do justice to the reality of the case. The court noted these aren't always easy decisions, and the factors typically don't all point the same way. But the court should be able to make its ruling quite concisely by referring to the main factors that bear on the individual case and identifying where the balance falls and why. And they said that the reasoned case management choice for judge who approaches the law correctly and takes all relevant factors into account will be upheld on appeal unless it's been shown something's gone badly wrong with the balancing exercise. The next case I'm going to look at is re-HW. This was an appeal by the local authority against the judge's refusal to hold a further fact-finding hearing in really long-running proceedings, which has started in 2020, concerning 4 children. The proceedings, by the time of the judgment that we're talking about, had already involved a fact-finding hearing and an appeal that went all the way up to the Supreme Court. And when it had got back down again, a non-subject child, referred to in the judgment as Y, made certain allegations against one of the fathers in the proceedings. This led the local authority to seek a further fact-finding hearing. They filed a schedule seeking findings not only against F3, but also against Y's parents, who were also not parties to the incident proceedings. After a hearing in November 2022, the trial judge concluded that it wouldn't be appropriate to give the local authority permission to pursue the further allegations. And he based his decision mainly on his view that the allegations related to events which had occurred when Y was between 2 and 6 years old, on which there appeared to be no medical evidence. And he also found that on the current information, the chances of the local authority proving the allegations were low. The local authority appealed. And the appeal was allowed. And they said that in deciding whether to hold a fact-finding hearing, it was imperative that judges conduct a proportionality analysis by reference to factors identified in the Oxfordshire case, as approved and developed by the Court of Appeal in re-HDH. And so really, there's a theme in all of these cases that you start with the Oxfordshire case, have a look at re-HDH, and that's really the start and end of it. What the Court of Appeal said was that the judge in this case hadn't been referred to either of those cases, unfortunately. If he had been, the Court of Appeal thought he would have conducted an analysis by reference to those principles. And those that should have identified that the magnetic factors in deciding whether or not to allow a further fact-finding hearing were the necessity or otherwise of the investigation and the relevance of the potential result to the future care plans for the children. One of the issues was whether F3 could play an effective protective role, and that was a crucial question. And the Court of Appeal also gave some quite useful guidance. They said, whilst each decision would depend on the circumstances of the case, the apparent quality of the evidence was unlikely to be a powerful factor in the overall decision, unless it was clear without the need for detailed assessments that the evidence appeared to be particularly strong or particularly weak. The judge had also been wrong to take into account the apparent absence of medical evidence, and the fact that the allegations were historic wasn't something the Court of Appeal felt which should have carried any significant weight in the analysis. So the Court of Appeal allowed the appeal and directed that a further fact-finding hearing should take place. The next case is a decision of Mr. Justice Leven. And this is Derbyshire County Council and AA and others. This is quite an interesting case. I think it raised a few eyebrows at first when the decision, the judgment was published. Mr. Justice Leven decided or held that a fact-finding hearing shouldn't be undertaken in this particular case. And she said, unless it's going to make a material difference to the welfare outcome in the orders which may be made. So far, so routine, you may think, but the facts of the case are quite interesting. Care proceedings have been started in respect to a very young child, X, who'd gone to hospital for a routine operation and was found to be suffering from healing fractures to 3 adjacent ribs. An application was made for an interim care or supervision order. That was refused, and the child remained at home under a complex and very full supervision plan. Over the course of the following 16 months, there were absolutely no doubts or concerns about the parents' care of the child. The general view of the experts who had then been instructed in the proceedings was that the injuries were more likely to have been inflicted non-accidentally, although the time window did include the child's birth. All parties agreed that there were no risk factors or red flags concerning either parent. The court had to decide whether or not to hold a fact-finding hearing, and it was decided that that was not necessary. The starting point, the court said, were the principles and the family procedure rules that we looked at the start of my section of this talk, including Rule 1.1, ensuring that the case is dealt with expeditiously and fairly, proportionately, and with fair allocation of resources. Mr. Justice Leven also considered the judgment that we were looking at, that Mark was looking at earlier in K&K, and specifically at paragraph 66, which Mark was looking at, in terms of what the court has to really focus on. Now, although that was a private law case, Mr. Justice Leven said that the principles as to whether a fact-finding is necessary and proportionate to determine what, if any, welfare orders should be made have equal relevance to public law. She then went on to look at the Oxfordshire factors as expanded on in re-HDH, and having gone through that exercise, she concluded that in applying those tests to the facts of this case, I've decided it's neither necessary nor proportionate to hold a fact-finding hearing. She said the fundamental purpose of public law proceedings is to determine what public law orders are needed for the welfare of the child and to protect the child from future risk. Understanding the facts and circumstances of an alleged non-accidental injury is often critical to the determination of future risk, but here she didn't find that was necessary. And she said, even if I made all the findings, it would be unlikely to have any material impact on the ultimate orders for X. The question that she was faced with was whether it was justifiable to hold a 9-day finding of fact hearing in order to determine whether it was appropriate to make a legally binding supervision plan as opposed to an agreed supervision plan, and the parties having agreed that those were really the two realistic outcomes of either course. And the court held that it would be a disproportionate use of court time to proceed with the hearing. At the end of the judgment, there's an interesting observation in respect of the need for a child and the parties to know the truth of what's happened. Mrs. Justice Leven said in this case that the benefit of finding out what happened is largely illusory. She said X is too young to know or care what happened. I think it highly unlikely that the parents would accept findings even if I made them. I cannot see any justification for a 9-day finding of fact hearing, so that at some point in the future, X can know the truth. The final case I'm going to look at is the case of P&E. That was earlier this year. This is an example of where things went slightly wrong. The judge at first instance decided not to hold a fact-finding hearing in circumstances where there were similarities to the Derbyshire case that we've just looked at. And those similarities led the judge at first instance to say that a fact-finding hearing was not necessary. The Court of Appeal held that whilst the judge had been quite right to give careful consideration to the question of whether a fact-finding hearing was necessary, she had taken the wrong approach in reaching her decision by comparing the facts in the Derbyshire case. In fact, the Court of Appeal disagreed that the facts of the case very closely mirrored those, as the judge had said. There were some similarities, but there were also some material differences between the two cases. So similarities included the fact that in both cases, sorry, Mark, I've gone back a bit, a young child had sustained injuries in the care of the parents. In both cases, the parents weren't able to provide an explanation as to how the injuries occurred. And in other respects, in both cases, social workers had formed a positive view of the quality of the parents' care. Both of the children were suffering harm as a result of the delay in the proceedings, which had already continued beyond the 26-week period in which they were expected to be concluded. But the material differences the Court of Appeal picked out were numerous. I've identified just a few here. First of all, in the Derbyshire case, the fractures were to 3 adjacent ribs, which led Mrs. Justice Leven to conclude that the fractures had been sustained in a single incident, or at least that was one conclusion open to her. In this case, however, the evidence indicated that the injuries would have been sustained or inflicted in at least 2 acts through different mechanisms, and that was significant. Another material difference was that in the Derbyshire case, there was no evidence to support any finding of deliberately inflicted injury, whereas in this case, there plainly was evidence capable of supporting such a finding, although, of course, the appeal court was clear that no such finding could be made without consideration of all of the evidence. Another important factor in the Court of Appeal's evaluation of the decision was the contents of the parenting assessment in P&E. This included the following observations. The assessor said that they couldn't safely make a recommendation as to how to manage the potential risk of harm to P&E should they be returned to the mother and father's care if the injuries have been inflicted, and or if the court hasn't taken a decision as to how they occurred, and that it would be incredibly difficult to manage risk if professionals aren't aware of the triggers and stresses which might have an impact on parental capacity to meet the child's needs safely, or indeed what the actual risks are. The Court of Appeal noted that none of those observations had been mentioned in the summary of the parenting assessment which the judge at first instance had given, and the Court of Appeal considered that that was a fatal flaw in the judge's reasoning. They went on to say that they agreed with the appellant's submission that the judge had erred in basing her decision on a comparison with the Derbyshire case, and that decisions of this sort should be made by careful application of the principles derived from case law. Comparison with decisions of other judges at first instance are unlikely to be helpful because inevitably each case turns on its own facts, and there's a danger that the comparison will be inaccurate. Here the judge concluded that other than the difference regarding current placement, I cannot see what else distinguishes this case from the Derbyshire case, but the Court of Appeal said that there were a number of significant differences. The court also said that there's always a danger with checklists of the sort set out in the Oxfordshire case, in that each factor can be seen as attracting equal weight, whereas some factors, if they're present at all, are always likely to carry greater weight. And they reminded us of Lord Justice Peter Jackson's words in HGH. Clearly, the necessity or otherwise of the investigation will always be a key issue. And in ReHW, they remind us that the court concludes the necessity or otherwise of the investigation and the relevance of the potential results to the future care plans for the children were on the facts of that case, the magnetic factors in deciding whether or not to allow a further fact-finding hearing. In this case, in P&E, it was held that they were also decisive factors, and the judge had been wrong to reject the local authority's submission that findings were fundamental. The adverse effects on the children resulting from further delay in reaching decisions is a very important factor, and the costs of proceedings and the impact on the expenditure on other cases are also relevant. And the court said that if the judge had been right to conclude that the potential result of the fact find wouldn't have any material impact on future care plans, then it probably wouldn't have been possible to challenge her decision. And in those circumstances, the importance for the children having a clear narrative about what had happened would probably not have justified continuing to a full fact-finding hearing. But the Court of Appeal came back to its decision that for the reasons set out in the parenting assessment, the fact-finding was necessary to provide a greater understanding of the risk of future harm. And without that understanding, it wouldn't be possible to make plans for the future care of the children which safeguard their welfare. Finally, the court said that the judge in this case was in no position to conclude at the case management hearing that an outcome where there was a decision that the injuries were sustained as a result of significantly inappropriate handling was one that was open to the judge at that case management hearing. And it would be unusual for a court to be in a position to reach such a conclusion at that early stage.
And then we move on to consideration of future developments. And I would suggest that, I think Alison and I would suggest that the question that does arise from looking at private law and public law is whether a difference of approach is emerging between public and private law proceedings in relation to fact finds and indeed outcomes in relation to fact finds or not. And forgive me, in order to address this, I'm just going to go back to the slides that I was having technical difficulties with earlier in relation to the Cafcass domestic abuse protocol, because I think they really clarify where there might be a difference of approach emerging. So I'm just going to zoom back through the slides quickly to the Cafcass domestic abuse protocol. So I'm going back through Alison's slides here, and these were the slides that I don't think displayed correctly earlier, so I apologise. As I say, the Cafcass domestic abuse protocol sets out starting points for which departure has to be justified, and they highlight the need for a Section 16A risk assessment where there's a sexual offence or other criminal act of violence in private law proceedings, and they're very clear that where there's been a report or disclosure of any form of domestic abuse, and the protocol does use the word disclosure, even though that's a contested phrase, I would suggest, including any sexual offence and a child's living with the accused parent, practitioners must urgently assess the child's safety and welfare. What it goes on to say, however, is that in considering recommendations for family time when there's been domestic abuse, practitioners cannot reliably predict what will be safe for a child. However, they can and must assess the child's safety and welfare, grounding this in the child's experience and the evidence and information that's provided. For example, a parent being investigated by the police for a sexual offence or has a conviction for a sexual offence and or a served prison sentence for a sexual offence provides a clear starting point to inform a recommendation for a child not to spend time with that parent. So as I say, for sexual matters, the domestic abuse protocol is very clear that in essence the starting point is no contact. And equally, it highlights quite properly the absolute relevance of domestic abuse. Practitioners must not dismiss or minimise domestic abuse as historical or as a one-off incident, because this is not only reveals a lack of understanding of the ongoing and long-term trauma of domestic abuse, but perpetuates it. It may also increase the risk of harm or further harm to the adult or child. In the protocol, it is interesting that it says practitioners shouldn't use phrases such as claims or alleges when a person reports domestic abuse. Rather, it should report what has been said. Moving on, practitioners must provide, so this is Cafcass practitioners, must provide a clear, unequivocal and compelling rationale in their reports to court for discounting domestic abuse as a risk to a child. So there couldn't be a clearer message to take domestic abuse seriously. And if a fact finding is being recommended along with the 16A risk assessment and referral to the local authority, consideration must be given whether it's in the child's interest to continue any direct time with arrangements that are already in place. And this is where I would suggest that whether to hold a fact find or not, and indeed contact arrangements, which logically are intimately intertwined with fact finds, certainly in private law, but actually in public law proceedings as well, is going to be a focus point. Because Cafcass, in essence, within this protocol, are being very clear that whether allegations are proven or not, whether matters have happened or not, is going to be crucial in determining appropriate contact levels going forwards. It's going to make those starting points, which is, to my mind, going to increase the necessity of fact finds, because more often than not, allegations are contested. And if Cafcass, as per this protocol, are going to make quite clear that the starting point, for example, when there's been sexual matters is no contact, there's going to logically be a need for a fact find in relation to that. And we continue on the next slide. Equally, practitioners must not support or recommend any contact, direct or otherwise, or spending time arrangements where the parent and child are currently living in a refuge, which is many domestic abuse cases. And when assessing the reasons why a child doesn't want to see a parent following separation, especially when a non-resident parent alleges parental alienation, practitioners must first consider whether the cause of this refusal is because the child is a victim of domestic abuse. So it's looking at parental alienation and saying, well, although we use that phrase, and arguably we shouldn't use it, in fact, it should be looking at alienating behaviours if one listens to the president more recently, you need to look at why the child might feel that way about a parent. What has happened? And it goes on, when assessing those who've been domestically abusive, practitioners must assess the lifelong harm caused by domestic abuse, not recommend the child spends time with a parent who has inflicted this harm on a child and their other parent without clear evidence that the perpetrator, A, recognises the harm behaviours caused the victims, B, taken responsibility for the harm they've caused, C, taken action to sustain change in their attitude and to stop their harmful behaviour, demonstrated over time, D, changes have resulted in an assessment that the risk of them perpetrating the behaviour has been removed to the point of enabling a recommendation family time is now in the child's interests. And generally, in protecting victims of domestic abuse, any departure from this starting point must be supported by a compelling rationale discussed with the manager. This, as I say, is Cafcass's internal protocol, but externally published, and recorded contemporaneously on the child's case record. And finally, it says, again, highlighting where there's a sexual offence, that in essence, the starting point is no contact. The reason I flag it, and whether there's a difference between public law and private law, is in private law proceedings now, Cafcass using this protocol are going to have to justify, frankly, any spending time with anybody against whom a sexual offence is alleged, and are going to have to justify any time with a domestic abuse perpetrator who doesn't accept the findings. My experience of public law proceedings, and I don't know how Alison feels about this, that arguably in public law we start from a very different remit. We do regularly have orders for local authority supervised contact, and granted it is local authority supervised, but we do have orders for ongoing face-to-face contact. And it does appear there is a gulf opening up between public and private law in that respect. And I'm bound to say my experience, and again, I'll hear what Alison wants to say about it in a moment, but actually in public law, sometimes issues are ducked in relation to such matters because they're not felt to be necessary to determine within the public law proceedings. But if these private law approach carries over, even within the public law proceedings, I think that will lead to more fact finds. I don't know what you think about that, Alison.
Yeah, I think that's right. Obviously, the Cafcass protocol applies just to public law cases as it does to private law cases. And it is common to have public law cases where there's domestic abuse, or sexual abuse, perhaps less so, but domestic abuse certainly rumbling along in the background, and perhaps for very good reasons. Everybody trying to plough on without having to determine the disputed issues. But then in light of the protocol, it's going to be very difficult for an alleged perpetrator to make any progress with contact if they continue not to accept allegations, for example, and therefore don't want to attend or can't attend a programme. And it's very difficult to see how they're going to move forward if the protocol, when the protocol is applied. One way might be, of course, to have those allegations determined, but I'm not sure how well that sits with the relaunch of the PLO, and in fact with some of the cases and the focus of them that we've been looking at.
And so I think we're going to have to watch this space, because in essence there are tensions running both ways. On the one hand, there is quite properly enhanced focus upon domestic abuse, sexual allegations and the impact on the child, which arguably require fact finds. But I'm bound to say, actually, in public and private law against that, the court's resources, as we all sadly know, are not infinite, and indeed are under extreme pressure. And juggling that on any given day is a difficult process to undertake. That then brings us on. I'm just going to go back through the slides. We've dealt with all of these slides to reassure you. But the last point on the slides, sorry, was questions, and I've just lost that now, but the last point on the slides was questions. And in fact, online, I think there's only been one question so far, which is, has there been any qualification on what deems fact-finding as a proportionate measure? And it was said there only seemed to be one case where it was deemed that fact-find was needed, Rio. In fact, there are two cases in relation to where a fact-find was found to be necessary. There was Rio, where I've indicated that, in fact, on appeal, there was criticism of the recorder for failing to realise, as it were, that a fact-find was required, even though actually non-molestation proceedings had previously been compromised and magistrates had previously taken a decision not to hold a fact-find. Mr. Senki Rio said there should have been. Also, MZA and FHB, Chaloner Judge Vincent, she did criticise the decision not to hold a fact-find in that case on the basis that, in fact, in that case, in essence, she felt there did need to be proper consideration of a fact find, and the way in which, in that particular case, the judge hadn't considered paragraphs 35 to 37 of PD 12J was improper, in the sense that would have led the judge arguably to have considered and found that a fact find was needed. And equally, procedurally, there were problems with the decision not to hold a fact find in that case. But in truth, whether to hold a fact find in any case is going to be evidence specific and fact specific. And so it's very difficult actually to come up with guidance more than perhaps K&K does. It's individual application, looking at the facts of any given case of the principles set out in K&K and other cases, certainly in private law, and I think in public law as well to a large extent.
Yeah, absolutely.
I think there's been one further question asked, which is, how will this affect historic decisions where Cafcass has determined direct contact should be allowed, supervised while police investigation progress? In truth, I don't know the answer to that. I think we have probably tied ourselves in knots, or Cafcass have tied themselves in knots in this regard. It is absolutely the case that several cases I'm involved with at the moment, judges have quite properly made decisions and they've considered all the factors, in my view, and they've decided there should be contact whilst allegations are pending determination. It's right that, as I've indicated, the Cafcass Domestic Abuse Protocol is fundamentally not a change in the law. It is a change in how Cafcass are recommending their own officers approach a case. It will still be for a court exercising its absolutely independent view and independent discretion to decide whether Cafcass are right or wrong in any given case. So I don't think the fact that matters have moved on for Cafcass necessarily alters or invalidates any prior decision. It does beg the question whether a different decision might have been made previously, and does beg the decision whether different decisions might be made in future. Alison?
We've got another question. Could an application be made to the court to permit unsupervised contact before a fact finding is held? Historically, judges have felt compelled to only permit supervised contact because it was their understanding of previous authorities. So,
in fact, I direct you to Rio in this case. Rio was a case where actually a judge had looked at potentially unsupervised contact before a fact find. And there have been decisions where, in fact, judges have been criticised quite heavily in recent times for ordering unsupervised contact before a fact find. There is, and I will email the person who's asked the question, but there's a recent authority involving, I believe, His Honour Judge Tolson. And the position is that in that case, His Honour Judge Tolson was criticised quite heavily for ordering unsupervised contact before a fact find, because the Court of Appeal said quite clearly that the entire point of holding the fact find was to ascertain the risk. And so if you didn't know the risk, you shouldn't be ordering unsupervised contact.
Often Section 7 reports are ordered before the need for a fact-finding hearing has been considered, on the basis that Cafcass will recommend whether one is required. And then an addendum report is ordered post the finding of fact decision. What's your view on this approach?
I think I'm not, for my part, I don't know how Alison feels about this. I'm not clear that's going to hold as an approach. I think, in fact, that in truth, part of the reason we order Section 7s before fact finds is because of the delay, actually, in getting a Cafcass report, and it varies across the country, but it's never less, in my experience, than 16 weeks, and so in some areas goes up to 24. And so that, in truth, is why Section 7 reports are being ordered. However, looking strictly at the protocol now, and indeed developments in case law, as I've indicated, you wouldn't have a Section 7 report, or you shouldn't have a Section 7 report that doesn't make recommendations. And if there's a risk factor that needs to be assessed, how can you write a Section 7 report before that's been determined? So I think certainly the filing date for the Section 7 report should be coming in after any fact find and after consideration of whether a fact find is needed. Whether you still order it beforehand to get yourself in the queue, as it were, we'll have to look at.
Please, can you clarify the weight of the Cafcass protocol and care proceedings going forward and its impact on a guardian's recommendations? It's an internal document, essentially, isn't it? It's guidance that Cafcass practitioners have to follow. I suppose the impact of it is going to be that is the approach that Cafcass are going to take, and we'll have to see how the other parties and the courts deal with this in practice. But in terms of its weight in a judge's decision, it forms part of the Guardian's analysis of, or the Guardian's recommendations, I think.
Yes, it's worth highlighting perhaps that as far as the protocol goes, it sets out starting points. It doesn't say Cafcass officers must do X, Y, or Z, or must not do X, Y, or Z. But what it does make quite clear is that if a individual Cafcass officer or guardian is going to go against the starting point, they're going to have discuss that with their manager, and they're going to have what's described variously as a compelling rationale at various points for having done so. So it will be interesting to see, I think, actually, whether that has an impact or not. And as I think now Alison and I have said, of course, what will be even more interesting to see is the extent to which that may lead to the courts increasingly taking account of Cafcass's views, but making clear that actually the Cafcass starting point is not necessarily where the court is. I don't know. It's too new, I'm afraid, at the moment, and we're going to have to all see how that develops in practice. I think there was one further question that came up on screen, but I am conscious of the time, and we've gone past our provisional hour. So I think with your permission, what we'll do is we'll leave that now. In relation to any questions that haven't been asked, we've got, or certainly we're able to see who has asked the question, so we'll make sure an answer is emailed out to everybody. To confirm, I know there's been questions. The slides will be emailed out, and this will be available on the YouTube channel. So thank you very much for attending. As I indicated, unanswered questions will be followed up by email. If you're watching the recording and haven't been able to join us live this evening, but have any questions, then do email through to events@42br.com, and we will do our best to answer those questions, even though unfortunately you weren't able to join us live. As I say, the recording will be available shortly, and we'd be grateful for any feedback, gratefully received. The next session in the series will take place on Wednesday, the 27th of November, where Eleanor Berthelsen and Max Montgomery will be exploring parental responsibility and presenting a guide from the basics of Jade's Law. So we hope you'll be able to join 42 Talks then. Thank you very much for your time, and good evening to you all.